Welcome to this presentation. I want us to go through the law of tort. Now, the word tort is derived from a Latin word tortium, which actually means to be twisted or crooked. Which means a tort becomes something that is crooked or twisted. Tortious liability arises from the breach of a duty primarily fixed by law, and this is a duty towards person generally, and it is normally redressed by an action of unliquidated damages. Tortious liability arises when someone has breached a duty that is primarily fixed by law. And the way in which we redress that is the court will issue an order to the defendant to pay unliquidated damages. Unliquidated damages are damages that the court is going to estimate based on the damages caused, injuries caused, among others. Those are some of the indicators that will determine the damages that are to be paid to the complainant in this scenario. Therefore, a tort is a civil wrong committed by a person against another, for which the remedy is a common law action for unliquidated damages, which is unspecified or unascertained. And like I've said, it is the court that actually, at the end of the day, estimates how much the defendant should pay the complainant. The principal aim of the law of tort is actually to compensate the victims or their dependents, so to speak. Now, there are certain other objectives of the law of tort. One, to determine rights between parties to a dispute, to prevent the continuation or repetition of harm, of course, by giving an order of injunction to prevent that person from continuing to cause that damage, to protect certain rights recognized by law, for example, to protect the reputation of an individual, because you have a right to a good name, to restore property to its rightful owner. So, for example, where property is wrongfully taken away from the rightful owner, to prevent against revenge and abuse of law, to protect intellectual property like copyright and trademarks, among others, and then to maintain peace, order, and harmony. Now, there are certain elements of the law of tort, or what we call the nature of tortious liability. To constitute a tort, there are three important elements that are key. One, there has to be a wrongful act. So the act complained of should be, under the circumstances, be a wrongful act as regards to the party complaining. So for there to be a tort, it is important that there must be a wrongful act, which means under the circumstances, the act is actually wrongful. And it is going to be said to be wrongful if it has prejudicially affected a person in their legal rights. So, of course, liability arises when the wrongful act complained of amounts to some sort of infringement of a legal right or a breach of a violation of a legal right. Number two, there has to be legal damage. Every infringement of the plaintiff's private right or unauthorized interference with his property gives right to legal damage. So if there's an interference with property belonging to another person, it could be land, trespassing upon a person's land. In that case, there's some sort of legal damage. There's some sort of legal damage, and there are two very important aspects about legal damage that are important in our case here. We have injuria sine damnum and damnum sine injuria. Injuria sine damnum and damnum sine injuria. Now, injuria sine damnum literally means an infringement of a legal rights of the plaintiff without there being any actual loss. So there is an infringement of a legal right, but there is no actual harm or loss. A good example to be able to explain that was a case between Ashby and White. It's a very old case that was decided in 1703 and was based upon an electoral. It was an electoral case based on an electoral issue. Now, the defendant was a returning officer. He wrongfully refused to register Ashby's vote when Ashby voted. The person who Ashby was voting for actually won the election. Uh, but be that as it may, Ashby went ahead and sued uh, White, the returning officer, for interfering with his right to vote. And the court said the defendant was liable because he deprived the plaintiff his legal right to uh, uh, right by failing to register his vote. It did not matter that the person, he did not suffer any legal harm because the person whom he was intending to vote for actually won the election. But the fact that his right to vote was interfered with by failure of the returning officer, the defendant, to register his vote was enough to constitute legal harm. Then we have damnum sine injuria. In damnum sine injuria, it is when there is an actual harm without there being any legal harm. So this scenario, a person has suffered actual harm, but there is no legal harm. And in scenarios where there is actual harm but no legal harm, there is no case that the defendant, against the defendant. Unfortunately for the complainant, in scenarios where there is actual harm but there is no legal damage, there is no case there to pursue. Because there has to be legal harm for you to be successful in a suit against the defendant. Now, damnum sine injuria arises in scenarios of ordinary trade competition or lawful usage of one's property. Now, Mogul Steamship versus MacGregor is an important case to be able to show us damnum sine injuria. So in this case here, some certain ship owners decided to drive a ship owner out of business. In this case, the complainant, the Mogul Steamship, they decided to offer cheap freight charges to customers who deal with them, with the idea of kicking the complainant out of business. So the plaintiff was eventually kicked out of business. He was not able to sustain his business, and he decided to sue MacGregor and the others for that. The court held that a trader who is ruined by legitimate competition of his rivals could not get damages in tort. So he could not get any damages in tort. That is because there was actual harm, there was no legal damage, and that is the scenario of damnum sine injuria. Actual harm, but no legal damage, and therefore there is no case. Injuria sine damnum, there is no actual harm, but there is legal damage. So even if there is no actual harm, a complainant will be successful because there is legal damage, which is what is important. The final element of tort is remedy. You're seeking for a remedy. You're seeking, the reason why you're taking this person to court is because you want the court to either order them to pay damages, or you want the court to order them to stop doing something that is causing you harm, and remedy becomes very important. So those are the three elements that are important in tortious liability. We have wrongful act, legal damage, and then we have remedy. The other thing we must ask ourselves: how do we determine tortious liability? How is tortious liability determined? And we base the determination of tortious liability from the fault principle. It is important to establish some fault on the part of the wrongdoer before he can be made liable in tort. It is very, very important to be able to prove that this person was at fault. A person is going to be said to be at fault if they fail to live up to some ideal standard of conduct that is expected of them or which is set by law. So that is what somebody is going to be said to be at fault as a result of. They failed to live up to an ideal standard expected of them under the law, which is set by law. So, for example, a medical doctor is expected to be careful in his treatment to the patient. A motorist who is using the road is expected to be careful. He has a duty of care towards other motorists, towards passengers that are in his car, and even pedestrians who are using the road there. He has a responsibility towards all those. He's going to be said to be at fault if he causes an accident that injures a victim, if it is proven that he fails to live up to the standards required of a reasonable motorist or a reasonable driver driving in such scenarios. Now, there are three ways to be able to determine whether someone was at fault or not. One is intention, two, recklessness, and three, negligence. Now, intention means a person did a wrongful act knowing the possible consequences, that they intended to accomplish that particular outcome. They knew what the consequences of their actions will be, and they went ahead and did it anyway. Take A is wants to hit B with a stone, throws a stone to B and B is injured. That is intentional because the idea there was for A to throw the stone to injure B. Two, recklessness. This is where a person does an act without caring what is the consequences might be. He's going to be at fault also. A wants to hit at a bird. He throws a stone, and he does not take into consideration that there are people passing within, and so he injures B as a result. That is recklessness. He ought to know that there's a possibility, even if his intention is to throw the stone to a bird, that he might actually hit at a person and not necessarily that particular bird. So in that scenario, he will be said to be reckless. Now, in negligence, however, negligence arises in circumstances where a person has a responsibility or has a duty of care towards another person. He breaches that particular duty towards that person, and that person suffers damages. A person is going to be therefore be said to be at fault because they were negligent under those particular scenarios. It is important to also note the concept of motive and malice in the law of tort. These two, motive and malice, are not important in determining whether someone was tortious or was tortiously liable. Now, motive means the reason behind the act of the defendant. What was the reason? Why did he do it? It answers the question why the defendant did what he did. Malice is when the motive is colored with ill will or ill motive. It becomes malice. Malice means desire or ill will to cause damage to someone. As a general rule, like I've mentioned, motive is irrelevant in determining liability in tort. A good or bad intention is not a defense in tort. So you can say a person was tortiously liable because they had the motive to do something. Someone can be very malicious under the law of tort and still not be be liable. I think one thing to note there is an important case called Bradford Corporation versus Picos. Now, Bradford Corporation and Picos were adjacent to each other, and Bradford wanted to, Picos wanted to sell a piece of land to Bradford Corporation, which Bradford refused to buy, and Picos became very annoyed. And because of his annoyance, he decided to revenge. And so what he did, there was water that used to percolate, not within a defined channel, but it would percolate into Bradford's corporation land. And because he was annoyed because Bradford had refused to purchase his land, he decided to go and sink some shafts that discolored the water and even caused the water not to percolate. So ideally, Bradford therefore did not have water. And so Bradford went to court for the court to issue an injunction against Picos for Picos to stop that. But the court found, of course, it's also important to note that Bradford also argued that Picos was very malicious in doing what he was doing. The court, however, held sorry, that an injunction could not be granted as Picos had a right to drain from his underground water, water not running in a defined channel. Remember, the water was not like a river. A river is water that is running through a defined channel. If you dig a borehole within in your premises, your neighbor does not have a right to your water. And even if in some way that you had dug something within your premises that produced water, and that water was percolating within your neighbor's land, he does not have that right to that water because the water is not running in a defined channel because it's not like a river or anything like that. So the court found that even if Picos was very malicious, he was not necessarily liable. However, malice and motive are important in some cases, like in defamation, in nuisance, in trespass, conspiracy, and all that. Negligence. You can't say, you cannot say that you intended to defame B but accidentally defamed C. Or someone has been defamed. There's malice there because the idea of defamation is to tarnish someone's name or mess their reputation out. So you cannot say, therefore, that you did not intend as a defense to defame Y. The intention was to defame Z, for example. Because, there is malice there. So those are some of the scenarios under which you can determine, therefore, that malice and motive are important in those scenarios. I have mentioned defamation, nuisance, negligence, malicious prosecution. I think I not mentioned that. Malicious prosecution. Uh, so we have defamation, nuisance, negligence, malicious prosecution, and trespass. Now, which brings us to the general defenses in tort. General defenses in tort. So generally, a plaintiff has to prove in a case in tort against a defendant. He has to prove that the defendant's act caused harm or damage to him or her. So, and judgment is passed against the defendant if the plaintiff is successful in showing that it is the fault of the defendant in terms of what has happened to the plaintiff. So there are certain defenses that the defendant has available to him, and if he's successful in his defense, then the case is going to be ruled against the plaintiff. So the first defense available to the defendant is what we refer to as volenti non fit injuria. Volenti non fit injuria literally means voluntary assumption of risk of consent. So the general rule is that a person cannot complain for harm done to him if he or she consented to run the risk of it. For example, a boxer, a footballer, a cricketer cannot seek to be compensated where they are injured or in the game to which they consented to be involved. Ronaldo, if he decides to play for Juventus in a match and is injured, there's a presumption that Ronaldo knows the possible outcome of the match, that he may be injured within a match and never play football ever again. Now, if he decides because he's injured by one of the players during a match to sue the player for the injuries that is sustained within a match, then the other player, whom he's accusing of causing injuries, may argue his case based on the defense of volenti non fit injuria. That Ronaldo voluntarily assumed the risk by his participation in that particular match. Similarly, a boxer who enters into a boxing ring, he enters there knowing, or it is presumed that he enters there knowing that there is a possible outcome that he may come out of that ring even dead at some point. Players even die in the fields, and volenti non fit injuria becomes a very important defense available to potential suits against other players that are within that particular match. The other thing to note about volenti non fit injuria is in as far as in medical law. In medical law, a doctor would have the defense of volenti non fit injuria in cases where a patient, say for example, consented to a particular medical procedure to be undertaken to them, and the doctor went ahead and informed the patient of the possible outcome of that particular procedure. So the patient gives informed consent for the procedure to be performed upon his body. And so if something happens to the patient, the doctor is protected by the disclaimer in that scenario. And here, his argument is volenti non fit injuria, that the patient knew of the possible outcome of that said procedure. Be that as it may, even before that, it's important to note that the defendant must prove two very important rules in his reliance of this particular defense. One, the plaintiff was at the material time aware of the nature and the extent of the risk involved. That the plaintiff was aware at the material time of the nature and extent of the risk involved. So a person cannot be able to consent to what is not within their knowledge. So the defendant must be able to prove that at the material time, the plaintiff was aware of the nature and the extent of the risk involved too. That the plaintiff agreed to incur the risk voluntarily. So by his consent, the plaintiff voluntarily assumes the risk of whatever consequences might follow from the act that he has consented to. That is very, very, very important. So he must have accepted the risk voluntarily. Now, if an employer tells the employee to go and clean a window in the 11th floor in a dangerously. So the window is in a very dangerous place there. The the employee goes and cleans the window and is injured, for example, while cleaning the window. Now then he decides, because of he's been injured while doing the work, he decides to take the employer to court. The employer starts saying, there was warranty and injury that this particular employee knew of the risk, the nature and the extent of the risk involved in cleaning that window. But the employer, it will be hard tasked to be able to prove whether the employee took those particular risks voluntarily. And it cannot be said that, the plaintiff took those risks voluntarily. He could have taken those risks because of his fear of losing his job and all that. So those are the two things that the defendant must be able to prove in volenti non finti. There are certain limitations, however, to the application of volenti non finti. One, there is no unlawful act which can be legalized by consent. You cannot legalize an unlawful act to be done to you. For example, you cannot legalize something like assault being done to you. You cannot legalize someone to do something that is unlawful to you. The other limitation upon which, of course, the defendant cannot be able to successfully use this defense, it will not have any validity against an action based on breach of statutory duty. It does not apply in rescue cases. It does not apply in rescue cases. If someone has, and if the plaintiff, under an emergency caused by the wrongful misconduct of the defendant, has faced a risk even to death to rescue another from imminent danger of personal injury or death, then the defendant cannot use volenti non finti as a defense. For example, there's a case there, I forget the name of the case, but the facts of the case were a man had left his horse unattended, and the horse posed a huge risk to a pregnant woman nearby and her two children. A police officer nearby also decided to rescue the mother and her two kids and was seriously injured by the horse, and decided to take the horse owner to court. The horse owner, of course, argued volenti non finti that the police officer at the time knew of the material risk involved and voluntarily decided to rescue the mother and her two children. But the court said that in rescue cases, volenti non finti cannot successfully be used as a defense by the defendant because he's the one that caused the risk in the first place, so he cannot use that as a defense. It also does not apply in negligent cases. It does also not apply where the act of the plaintiff relied upon to establish the defense under the volenti is the very act which the defendant was under duty to prevent. Now, that is volenti non finti, which is the first important defense available to a defendant. Number two, we have inevitable accident. Inevitable accident means an accident which cannot be prevented by the exercise of ordinary care, caution, or skill of an ordinary man. It occurs where there is no negligence on the part of the defendant, because the law of tort is based on the fault principle. So, of course, inevitable accident occurs in scenarios where a defendant could not have prevented the accident from happening by the exercise of any reasonable care or caution. A good important case is a case between Stanley and Powell. Powell and his friend had gone to do some pheasant hunting. Pheasant is a type of bird. And so they had hired, Powell had hired Stanley to carry for him his cartridges. Cartridges are things I think you put in the gun to enable the killing of the hunting of the bird. So when Powell, shot at the gun, the bullet went and lodged itself upon a tree, and then rebounded, and then went and hit at, Stanley's eye, seriously injuring him. And he decided to sue Powell for that. And the court said that the defendant was not liable in the light of the circumstances of inevitable accident. Now, number three, we have the act of God. So where damage is caused by the directly by natural circumstances or force that are unconnected with human beings, or which no human being, no human forethought can prevent. and of which human carefulness is not bound to recognize. So, in other words, an act of God is where injuries or damages are caused uh, by natural circumstances which are not connected to any human act, and which no human being could have prevented. In Nichols versus Marshland, the defendant had a number of artificial lakes on his land. So unprecedented rain fell, and as a result, the banks of the lakes burst, and the escaping water carried away 4 bridges belonging to the plaintiff. It was held that the plaintiff's bridges were swept by an act of God, and the defendant was therefore not liable. Then we have necessity. Uh, necessity can also be used as a defense when a person finds himself in a position whereby he is forced to interfere with the rights of another person so as to prevent harm or a harm upon himself or his property. So he interferes with the rights of another to prevent more harm from happening to himself. And also in Cobb versus Sharp, the defendants committed certain acts of trespass. There was a fire in his employer's land, the neighbor of his employer, and decided to trespass upon that land to go and switch off the fire because the fire was posing danger to spread into his master's or his employer's land. The court therefore said that the defendant was not liable as the risk of his master's property was real and imminent, and a reasonable person in his position would have actually done the same. Circumstances when necessity can be used is where there is urgent situation or imminent danger, and where the measures taken are actually reasonable. The other general defense of tort is self-defense. Everyone has a right to defend himself. You do not have an obligation to run away when you are attacked. You have a right to defend yourself. And self-defense is also referred to as private defense. And if you are attacked, you have a right to defend yourself. However, there are certain conditions that must be met in this particular defense. One, the force must be reasonably necessary, because if you're attacked verbally, it is unnecessary to to defend physically if the attack is verbal. It is unreasonable to defend yourself physically from a verbal attack. So two, the means of defense must be related to the harm. Having a fierce dog to protect yourself from burglary or people coming to steal from you within your premises. The force, number three, the force used in self-defense must be reasonable and proportionate to the attack. It is very, very important that this defense be reasonably proportionate to the defense. If a person attacks you using a knife, or if a person slaps you, I think it would be unreasonable to use a knife to defend yourself. And of course, there are many other dynamics that are going to be considered: the sizes of these individuals, sometimes even the gender, experience. So if a person is experienced in taekwondo and is attacking you, no matter how big you are, his experience may be quite different from in that case. And then the self-defense must end the moment the attack ends. Now, this guy, the moment he stopped attacking you, then you must also stop the defense. You cannot continue in your defense while the attack has already ended. Number 6, the other defense of tort is mistake. When we say normally, uh, the mistake of law of fact is no defense. Say ignorance of law is no defense. But there are scenarios where mistake becomes important as a defense, like in malicious prosecution. In malicious prosecution, where a police officer has arrested someone wrongfully uh, without knowing that he's not the person that is who committed the wrong. For example, where the suspect looks like someone else and you attack that other person, or rather you arrest that other person and he's taken through prosecution. Uh, if the police officer is taken to court for malicious prosecution, he may say he was under mistake and can use that as a defense to defend himself against such allegations. Then you have statutory authority, which is the number 7 defense. So where the commission of what would otherwise be a tort is authorized by a statute, the injured parties, their injured parties not becomes or remains without a remedy. Of course, unless the law has, or the said provision of law has provided for uh, some sort of remedies. Like, for example, if you live next to the airport authority is given permission under an act of parliament to commit certain nuisances or certain noises because of the nature of of the service rendered by the said, authority. And so, even if you took the airport authority to court for nuisance, it would have the defense of statutory authority that it is permitted to commit those torts under an act of parliament. Then we have novus actus intervenes as the other general defense of tort. This is when a chain of events result from a tort, so that the loss suffered is not within the scope of those that would naturally occur from the first tort. Uh, to refer to a novus actus interveniens is in fact merely another way of saying that the loss was not reasonably foreseeable. Now, novus actus interveniens occurs where there is a break of chain of causation. For example, a scenario where a case in point of a young man who decided to poison his mother, and before the mother could die of poison, the mother died of a heart attack. Now, it would be improbable that this son would be held liable for murder, maybe attempted murder, but not murder, because there was novus actus intervening. Something happened that broke the chain of causation, which was a heart attack. Because ultimately, the ultimate cause of death was not the poison, but the heart attack. Another example of novus actus interveniens is a case in point where two men fought in a bar. One of them took a broken bottle and stabbed the other, and he started bleeding. And so his friend decided to rush him to hospital. He was a heavy-set man, and on their way to hospital, they kept dropping him. By the time they were arriving at the hospital, he had been injured, and the injuries that he had sustained uh, in the pub could not have caused death. But the fact that he was dropped several times by his friends meant that he had been more injured. So something happened that broke the chain of causation. So the first thought, which was him being stabbed, could not have caused death because the nature of the stab could not have caused death. But the drop-in by the friend ultimately is what caused the death. That was a chain of causation. That is what novus actus intervenes. So the death was not, the injury at the pub was not the proximate cause of death, which means that that particular individual is not liable or culpable for death. Maybe assault, but not necessarily death. Then we have contributory negligence is a final um, defense of tort. So the defendant may rely upon this defense if the plaintiff also is to blame for his own sufferings. So the defendant is required to prove that the plaintiff exposed himself to the risk by his own act of omission, the plaintiff was at fault or was negligent, and then the plaintiff's negligence or fault contributed to his suffering. So he must prove that. He must be able to prove those cases. So the defense of contributory negligence is normally not to absolve or to release the defendant from liability, but it is to apportion the blame between the defendant and the plaintiff. For example, the defendant may argue that, for example, if it's a motorcycle rider who is injured by X, who's driving a car, a Probox, he causes an accident that injures Michael, say for example, who is the motorcycle rider. And for example, the argument here would be, because you're talking about contributory negligence, um, Julius, let's call him Julius, the owner of the car, if he's taken to court by Michael, and he decides to use a contributory negligence as his defense, he'll be arguing, had Michael worn a helmet, he would not have sustained 20% of the injuries. If he's able to show that, then if the court orders that he pays 200,000 to Michael, he will only be culpable. I mean, he will only be liable to pay 180,000 and not the whole amount, because they are apportioned in the blame. My blame is 80% of your injuries. The other 20% of your injuries, you're the one who's at fault of them, and that becomes contributory negligence. And that idea is what uh, the basis of the law of tort. It's not the full of it, but that is merely the introduction bit of the law of tort. And I think we will continue from there as we